Well, welcome everybody. I think there will be a number of people still joining the session, but in the interest of time, let's kick off. Welcome to the third session in our seminar series on how businesses can operate responsibly in conflict-affected and high-risk areas. I'm Lara Strangways. I'm the director at Beyond Human Rights Compliance and head of business and human rights at Global Rights Compliance, and I'll be moderating today's session. It's great to see so many of you joining us, and I think it's going to be a timely and thought-provoking discussion considering world events at the moment. For some of you that joined last month's webinar in March, we explored the applicability of international humanitarian law, or IHL, to businesses, including lessons from the Lafarge case. And today we'll really build on that webinar and we'll turn to one of the most challenging environments for businesses, situations of occupation. So the session will focus on occupation and how it applies to businesses operating or connected to occupied territories. And we'll explore some of the complexities that arise in relation to these environments, particularly how businesses can end up contributing to violations of fundamental principles of international law. That's including and especially IHL, war crimes such as forcible displacement, transfer of the occupier's population into territory, unlawful use of public and private property, and a number of others, including the right to self-determination, non-discrimination, and other fundamental human rights. So there's a couple of leading questions that for those of you that will have seen our LinkedIn posts about the key questions that we're seeking to answer in today's webinar. What constitutes responsible business conduct in occupied territories? How can businesses mitigate risks of complicity in human rights abuses? And is it possible to operate in these environments without violating fundamental principles of international law? So we're very lucky to be joined by two expert panelists who will guide us through these issues in different contexts, and I'll introduce them both in a minute. Just a few quick housekeeping points before we start. We do have a 60-minute session today. We've got around 40 minutes of presentation and 20 minutes of Q&A. And we'll aim to keep each speaker's remarks concise to allow for more questions to be answered. So please do feel free to use the Q&A box at the bottom. You can write your questions, and as I said, we'll try and get through as many as possible during that Q&A segment at the end. If you experience any technical difficulties, we have Yuri, who is our IT expert on the call and is able to help with any of those queries in the chat if that's helpful. And finally, the session is being recorded, so we'll be able to circulate the slides and key takeaways afterwards. So quickly about our speakers, we're joined by Richard Rogers. Richard is the founding partner of Global Diligence, an international legal advisory firm specializing in human rights, international criminal law, and corporate compliance in conflict-affected environments. He's been a driving force behind the creation of modern ecocide laws. He co-authored the international legal definition now used globally, and has landmark international criminal court filings on land grabbing, Amazonian destruction, and has inspired global action. Richard has also undertaken several projects in Western Sahara, assisting businesses to navigate the human rights challenges as they plan operations, and will indeed be speaking about some of that today. We're also joined by GRC's Wayne Jordash, KC, whose internationally recognized expertise in international human rights law has led him to advise governments, including the UK, Netherlands, Ukraine, Bangladesh, and Vietnam, multilateral organizations such as the UN and EU, and business and industry bodies and civil society organizations. He's recognized in Legal 500 as one of the world's leading international criminal lawyers and has over 15 years of experience supporting businesses to navigate these complex questions that we'll be talking about today. So thank you both for being here. And Wayne, I will pass to you first.
Thank you very much, Lara, and welcome everyone to this webinar. I will just dive straight into it. This is a webinar to try to understand some of the challenges of working in occupied territories, including in the occupied Palestinian territories and Western Sahara. It's not an exaggeration to say these are some of the most complicated territories to navigate for businesses. the plethora of law is complicated even to international lawyers, as I'm going to try to discuss in the next 20 minutes. But to frame the discussion, please have a look at slide 2. What are we talking about in these environments for businesses? We're talking about their obligation to conduct heightened human rights due diligence. Why do they need to conduct heightened due diligence? Well, because they need to assess not just the potential negative impact they may have on rights, but also the impact they may have on the dynamics of any conflict. And occupations are inherently, integrally international armed conflicts, irrespective of whether there is actual armed hostilities during the period of active business operations. So let me start the discussion with what is an occupation. I'm going to try not to get bogged down in the law over the next 20 minutes, although I apologize in advance. It's very difficult not to, because what we're really talking about are very specific legal qualifications with legal thresholds, both in terms of what creates an occupation, what turns an occupation into something illegal, and what are the potentials for rights violations during an occupation. It is all law. So what is an occupation? Well, an occupation is, as I've mentioned, an international armed conflict where the territory of a sovereign state is placed under the authority of another state through the auspices of a hostile army. An occupation extends to the part of the territory that is effectively under the authority of the hostile army and exists even if the presence of the army is not met with armed resistance. How do you determine whether an occupation exists? You have to answer essentially 2 questions. Is the territory answering to another sovereign state? And 2, are the criteria laid down in Article 42 of the Hague Regulations met? What are those criteria? As stated in Article 42 of the Hague Regulations, a territory is considered occupied when it is actually placed under the authority of a hostile army. However, an occupation does not require the continued physical presence of the occupying power's military forces. It is sufficient that the occupier is capable of enforcing its authority, including by making its physical presence felt within a reasonable time. That explains the ICJ finding in 2024 in relation to Gaza, that even after the departure of the Israeli army, this is pre-October the 7th, obviously, there was still an occupation. Why? Quote, based on the information before it, the court considers that Israel remained capable of exercising and continued to exercise certain key elements of authority over the Gaza Strip, including control of the land, sea, and air borders, restrictions on movements of goods and people, collection of import and export taxes, and military control over the buffer zone, despite the withdrawal of its military presence in 2005. This is even more so since October the 7th, 2023, close quotes. So, although occupation-related IHL rules are always premised on the same assumption, that essentially there has to be control by a hostile army, one can see how the law is effectively shifting to one of more general control over the occupied or the territory alleged to be occupied. A couple of other points. One, an occupation is supposed to be a temporary situation. I'll come back to that in a minute. But that does not mean if an occupation goes on a long time, that somehow it is no longer an occupation. This was an argument advanced and rejected by Israel, by the ICJ, the International Court of Justice, in 2024, and in the Wall case as well. So, what does it mean for a business working in occupied territory, or a business whose products may derive from occupied territory, or otherwise the business benefits from resources from those territories? What are the legal principles that must be addressed as part of your heightened due diligence? 3 legal considerations loom large. 1, you need an assessment of the legality of the occupation based on relevant law. 2nd, if the first step shows that the occupation is being conducted in violation of the relevant legal rules, it will be then necessary to identify what are the violations specifically and what international crimes might result from the violations. And finally, the 3rd legal consideration that looms large, the business activities have to be analysed in order to determine whether, and if so, to what extent, the business is contributing to, or linked to the commission of those violations identified in the first 2 legal considerations. So let's just take the first consideration. Has to be done, no way around this, assessing the general legality of the occupation. Look at slide 4. This essential question from a holistic perspective is the occupation, or does the occupation amount to an annexation? Annexation amounts to the forcible acquisition by the occupying power of the territory that it occupies, namely its integration into the territory of the occupying power. That is a violation of Article 51 of the UN Charter, which gives rise to obligations on all states to refrain from supporting such an illegal use of force amounting to an annexation. An annexation, however, is in a sense a global term which contains a range of potential violations. As summarized by the Committee on the Exercise of the Inalienable Rights of the Palestinian People, annexation is, quote, a breach of the prohibition on the acquisition of territory by force, that's 1, a violation of the right of self-determination, that's 2, and an act constituting the international crime of aggression, incurring individual criminal liability, that's 3. As you will see from the brief presentation, there is much more contained within, or much more potential violations contained within an annexation. So annexation amounts to violation of fundamental principles, but it also almost inevitably, I would say, amounts to a violation of various international humanitarian law principles. Occupations are generally, and I'm generalizing, but they are largely governed by the 4th Geneva Convention and the Hague Regulations. And the essence of an occupation is that it's temporary. So what you have is, for example, Article 43 of the Hague Regulations. The occupying power is obliged to respect in principle the laws of the occupied territory in force. Article 54 of the 4th Geneva Convention, the occupying power may not alter the status of public officials or judges in the occupied territory. If you look at the totality on even the specifics of the Geneva Convention and the regulations governing occupation, they all tend towards showing that an occupation must be a temporary state of affairs. Slide 5, and this is what Richard will address in some depth, I believe, the best interests of the occupied population. Contrary to what is implied by annexation, any occupation should be conducted in the best interests of the occupied population. So it's crucial that businesses operating in occupied territories ask that very simple question. At a minimum, are your activities upholding human rights? Are your obligations violating the prohibition of transferring property rights? Are your activities in any way violating the obligations to administer the territory in a temporary way, i.e. that is not use its natural resources as you wish, but use its natural resources for the benefit of the occupied population? And obligations to secure food supply, obligations to take measures to respect the laws in force in the country. these are the type of questions which arise in occupation, and these are the questions which businesses must be prepared to answer through their heightened due diligence. These are fundamentals. In summary, the occupant is permitted to administer the occupied territory while considering its own security interests. However, it must consider the population's interests and the maintenance of the status quo as far as possible. See slide 6 for the ICJ's view of Israel's violation of this best interest principle in the occupied Palestinian territories as regards the use of natural resources. See also slide 7, which sums up the ICJ's 2024 conclusion that Israel's occupation of Palestinian land in the OPT amounts to an annexation. It includes, according to the ICJ, the maintenance and expansion of settlements through forcible transfer of populations, demolition of properties and discriminatory permit policies, the construction of associated infrastructure such as the road network, the exploitation of natural resources, the proclamation of part of the occupied territory as the capital of the occupying power, and the application of the occupying power's domestic law in the occupied territories. In other words, any business seeking to operate in an occupation made illegal by annexation will be working in an environment that involves numerous violations of international humanitarian law, international human rights law, and also public international law that operate to de facto transfer sovereignty to the occupier. So whilst a business may avoid causing any such violations in such a system, it is highly unlikely that business activities will not in some way be linked to those violations, including the annexation as a whole. That's the nature, the systematic nature of an annexation. But even if the occupation does not amount to an annexation, that does not mean that businesses do not face dangers ahead. To the contrary, the various rules of IHL and international human rights law must always be at the heart of any assessment to ascertain which rules have been violated, which international crimes might be resulting from such violations, irrespective of whether there is an annexation or not. It does not mean, because there is not an annexation, it does not mean because the violations don't amount to an illegal occupation that a business will not be linked to violations of specific individual rules of international law. So two main questions. Is international humanitarian law being violated? Secondly, is international human rights law being violated? Please look at slide 9. You'll see relevant IHL provisions in the occupied territory. Most obvious ones, the most compelling ones for businesses probably are prohibition of individual or mass forcible transfers, obligations not to deport or transfer part of the occupying power's own civilian population into the territory, obligation to not destroy property belonging to private persons, which includes, of course, obligations not to confiscate property, which is also dealt with by the Article 46 of the Hague Regulations. And finally, and this again goes to the more systematic possibility of violations or violations of a more systematic nature, Additional Protocol 1, an obligation not to engage in practices of apartheid and other inhumane and degrading practices involving outrages upon personal dignity based on racial discrimination under Article 854C of Additional Protocol 1. Let me just quickly, we're short of time, but just give you an example of how these rules might operate. Take, for example, the respect for and prohibition of confiscation of private property under Article 46 of the Hague Regulations. According to the ICJ, the Israeli settlements in the occupied Palestinian territory rely on policies and measures that contribute to the annexation of the OPT. However, individually, these policies and measures can be seen as a form of violation and confiscation of the Palestinian people's private property, violating Article 46, which state, as I've said, that private property must be respected and cannot be confiscated. As the ICJ noted when discussing the illegality of the Israeli settlement policies and activities relying on the confiscation of expropriation of Palestinian-owned private property does not, quote, does not allow for exceptions, whether for military exigencies or on any other ground. Thus, as a matter of law, according to the ICJ, there can be no justification for Israel's oft-observed confiscation of Palestinian private property and replacement by Israeli settlements. So businesses need to look at these individual components of what might, in some circumstances, amount to annexation, but in and of themselves, if shown to be fulfilled, amount to war crimes. Is a business causing them, contributing to them, or linked to them? That's what the heightened due diligence must address, must inquire into, must investigate, and come to firm conclusions about. And finally, the rules of international human rights law are also applicable to occupation. For example, as you'll see from slide 9, the occupied people have a right not to suffer discrimination. What does that entail? It entails that no matter their race, color, sex, language, religion, political or other opinion, national or social origin, property, birth or other, should have their rights respected and ensured. A discrimination which violates this right is the result of a differentiation of treatment based on one of the criteria I've just outlined that is not justified, meaning reasonable and objective and serving a legitimate public aim. Again, this is the question for any business operating in occupied territories, and it's a question which is addressed again by the ICJ in 2024 in relation to Israel's policies in the OPT, where the court found the existence of an unjustifiable Israeli discriminatory policy, which was underpinned by various activities, including a residence permit policy, wherein residents in East Jerusalem wherein residence in East Jerusalem was unrestricted for Israeli citizens and non-Israeli Jews, but all other residents, including Palestinians, were regarded as foreign nationals. The promotion of illegal construction outposts by Jewish settlers, the demolition of property belonging to Palestinians, and so on and so forth. This, according to the ICJ, amounted to a violation of discrimination. Moving quickly to my final point, and I hope what I've done in the last 20 minutes is just to give a flavor of the various legal rules which apply, which must be analyzed. But what really counts in the end is the business activities needing to be analyzed in order to determine whether, and if so, to what extent, the business activities, the products, the supply chains are causing or contributing or linked to any violation of these rules that I've just outlined. And this is a tricky question as a consequence of the complexity of the rules, how much of the activity that they cover, and the numerous ways in which businesses can be linked to such rules. Critical questions. How do those business activities go towards the establishment and maintenance of the dynamics of the occupation, particularly any illegality, i.e. particularly any annexation? 2, how do these business activities relate to violations of IHL and international human rights law? For example, do the business activities relate to IHL and the obligations of the occupying power under the Geneva Convention, number 4, and the Hague Regulations, by, for example, undermining the occupied population's ownership, possession, and access to private property, through exploitation of public resources such as water, forestry, minerals, or by facilitating the transfer of the occupying power's population into occupied territory, or vice versa, the forced displacement of the occupied persons. And number 3, do any of these activities raise the question of individual criminal responsibility, i.e. war crimes, or specifically war crimes, for any participating business or individual from that business? And of course, that is why we need heightened human rights due diligence. That's why human rights risk assessments are so critical in occupation situations. And for that, I'm going to turn now to Richard to explore these issues in relation to Western Sahara.
Thank you, Wayne. And yes, let's now turn to Richard, who will discuss his work in Western Sahara, including the complexities surrounding the unresolved status of the region and the approach that companies should take to ensure compliance with human rights norms. Over to you, Richard.
Yes, well, thanks very much, everyone, for joining, and thanks to GRC for inviting me. GRC is doing some really solid and inspiring work on business and human rights, so it's great to be part of this event. So I'm the founding partner of Global Diligence, which is a legal advisory firm. We specialize in international criminal law and international human rights. And as part of that, we offer assistance to businesses who are seeking to operate in these complex zones, including Western Sahara. So I'll be talking about some of the key challenges for businesses who are interested in operating in Western Sahara. I've worked on 3 projects now. Each one has raised its own unique issue and required slightly different forms of engagement. But one thing has been consistent for all of them, and that is the political sensitivity and the legal complexity of the environment. And Wayne very helpfully laid out the law. It can be even more difficult to apply the law actually in practice, even than understand the framework. So for background, the businesses I work with have been involved in industries such as renewable energy, desalination, agriculture, and they sought our assistance at the early stages of the project so that they could comply with their human rights obligations. Now, what I'd like to focus on today is the broader question relating to the human right of self-determination, because that is key to this type of context. It helps us answer the essential question of whether businesses are even allowed to operate in Western Sahara at all, in any capacity, however beneficial it might be. Of course, the other human rights are important and need to be dealt with on a more granular level, but the place to start is an assessment of self-determination. And that requires, as Wayne mentioned, it requires us to understand the legal status. So in terms of Western Sahara, this is where it gets really tricky. It has an unresolved status. It's not even clear whether we're talking about an occupied territory or not. That depends on who you ask. If you ask Morocco, the United States, Israel, it's not occupied. If you ask Algeria, South Africa, many other countries, it is occupied. And it's a changing landscape, as many of these situations are. But I think for businesses, it's best to work on the assumption that they will be operating in an occupied territory. In terms of the sort of more factual and legal context, Morocco administers 75% of the territory. It claims that it owns the whole territory and refers to that as the southern provinces. It has an autonomy plan that it issued in 2007, which allows the populations of Western Sahara to enjoy self-determination through making the region this semi-autonomous area, but ultimately under Moroccan sovereignty. So according to the autonomy plan, and I quote, the Sahara populations will themselves run their affairs democratically through legislative, executive, and judicial bodies enjoying exclusive powers. But ultimately, Morocco would deal with defense and foreign affairs, etc. But despite these efforts to find a solution, there has been armed resistance on and off since the 1970s. Led by the Polisario Front and supported by Algeria and indirectly Russia. The position of the Polisario Front is in essence that the territory is under illegal Moroccan occupation and that any business operations, no matter how beneficial, are illegal and immoral. The situation on the ground now is very peaceful, but it is worth remembering that the Moroccan military built the second largest wall in the world, the Bern Wall, and they built that around the area they control, and they have 100,000 soldiers guarding that part of Western Sahara. So it's obviously not that peaceful. The Polisario Front, and I think it's fair to say an ever decreasing number of states, claim that only full independence from Morocco will satisfy self-determination of the people there. Other Sahrawi groups are much more supportive of Morocco's administration and their autonomy plan. And the UN itself doesn't add complete clarity. It officially considers Western Sahara to be a non-self-governing territory where the process of self-determination remains to be completed. But on the other hand, the UN Security Council has issued over 30 resolutions on Western Sahara. And the last time it mentioned the word occupation was 45 years ago. In fact, the more recent UN Security Council resolutions have spoken much more about Morocco's autonomy plan and seem to find that very credible. So to add into this already complex mix, in December 2020, the US and Israel recognized Morocco's full sovereignty over Western Sahara. So to sum up, in practical terms, it's generally accepted that the idea of full independence is no longer seen as viable by the UN, by Morocco, by most European nations, by the United States, and by others. Internal self-determination in line with Morocco's autonomy plan is considered to be the only serious and credible way forward at this stage. So where does that leave us in terms of self-determination and business operations? Well, as we've seen, the law is very messy, but for businesses wanting to operate, it's safest to consider Western Sahara as an occupied territory where self-determination will ultimately be addressed internally with Morocco as the administrative power. That does not mean that businesses cannot lawfully operate there, despite what the Polisario Front will tell you. It does mean that businesses should act with extra caution and sensitivity and help ensure that they do not contribute to human rights violations of the local people. So what does this extra caution look like in practice, and how should businesses approach this issue from the start? Well, thankfully, we do have some guidance on this. In 2002, the UN's most senior lawyer, Hans Corell, was asked to clarify the conditions for lawful resource exploitation in Western Sahara. So the very issue that many businesses are interested in. And in his legal opinion, he laid out a test, which I think is widely accepted as a standard to be applied in such situations. And he basically stated that in non-self-governing territories, resource exploitation conducted for the benefit of the peoples of those territories and on their behalf or in consultation with their representatives is compatible with the UN Charter and the obligations of the administering power. So this is a safe test to apply for any operations, even if it doesn't involve resource exploitation. So when designing an assessment for this broad issue, we basically need to determine, is the operation beneficial to the Sahrawi people concerned with the project? Is it being done in consultation with or in partnership with their representatives? So let's have a look at how we apply that test in practice. So first, it was important to understand the context, and this involved studying a whole range of documents from Morocco's autonomy plan, prior reports relating to the specific projects, court rulings relating to Western Sahara and their applicability to private businesses, recent human rights reports. And it was also important to undertake stakeholder engagement with UN bodies there, with Moroccan ministries, with the Polisario Front or their civil society organizations who support them, and of course, and most importantly, with the representatives of the people themselves. Choosing the representatives was not straightforward either. It's an extremely sensitive question. There are very strong views about who represents the Sawari people, who represents them generally, who represents them in the region of the operation. Of course, Morocco claims to represent all residents, but that is legally and politically contested. And it's the same with the Polisario Front. And we confirm through interaction and desk research that the maximalist position of the Polisario Front remained unchanged and unhelpful to the benefit analysis. And there were real questions about whether the Polisario Front was acting in good faith, given that they prefer absolutely no investment whatsoever, even if it benefits the Sawari people. So what became clear was that there is no single representative person or body for all the Sawari people. So we decided to undertake a more nuanced assessment of the real stakeholders relating to the given project. So who were the communities actually affected by the projects? Where did they live? How were they represented, etc.? And for example, in the southern area of Dakhla, which is home to many Sawari people, the region has a political system that is fundamentally democratic. The regional government is comprised both of elected and appointed officials. And for the projects operating in that region, in Dakhla, we felt satisfied that these actors, the vast majority of them being Sawari, were the representatives of the people for the purposes of the benefit analysis. We met those representatives in Dakhla. We discussed the projects, we discussed any concerns. We met people like regional directors of agriculture, president of the regions, MPs, all Sawari people. And in all three projects, the representatives were supportive of the investments. And depending on the project, they stressed issues such as the desperate need for affordable fresh water in the region. They pointed out that the conditions were perfect for agriculture if they had fresh water for irrigation. They expressed how important it was to create new jobs in the region, particularly for young people, and to diversify away from commercial fishing, which is the main industry. They talked about how the youth were now well trained in agriculture and business, but didn't have enough jobs. They talked about how clean energy would be important, not just to run the project itself, but to feed into other areas, providing energy for Dakhla. They hoped that this type of investment would lead to social improvements. They hope that the refugees would eventually come back and participate in this life and reap some of the benefits from this investment. So basically, certainly in relation to the projects that we assessed, we found that for the Sawaris currently in the region, there were clear benefits that were likely to enhance their self-determination, enhance them to freely pursue their economic, social, and cultural development. For the returning Sawaris, their right to return was unaffected by the particular projects that we looked at, and they too were likely to benefit if and when they did come back. And for the Sawaris living east of the burn line, the project had no bearing on their self-determination. And of course, we made a whole number of recommendations to each of the companies to help ensure that the situation was properly monitored and that the company could adapt to any changes. And of course, as I discussed at the beginning, this was just an assessment of the bigger question of self-determination. And on top of that, the businesses needed to carry out much more granular assessments of the other human rights issues, whether they be labor, health, environment, freedom of association, etc. Yeah, so just to wrap up, so I think that Western Sahara is a very good example that demonstrates the complexities of operating in regions of unresolved status, where the legal ambiguity, the political sensitivities, and the human rights risks all collide together. The region definitely needs investment, and if it's done right, it can provide a real benefit to the local people. Thank you very much.
Wonderful. Thank you so much, Richard. Some really interesting points that came out there, and interesting to hear more about your work in Western Sahara. We now have 20 or 18 minutes till the end of this webinar, which we are dedicating to Q&A so that we can answer any of those more complex, tricky questions that maybe we can do live rather than through writing. So I do encourage everyone to put their questions into the Q&A section at the bottom or the chat. But to kick us off, maybe we can just talk about how businesses can negotiate these complexities in terms of also commissioning some of these assessments. When is the right time for them to start engaging maybe experts or external organizations outside to start assessing some of these risks that both Wayne, you and Richard have been speaking about during your panel. Wayne, maybe I'll turn to you first, and then Richard.
When is the right time? Let me answer that by saying or talking about heightened due diligence. As I indicated during my presentation, we are talking about 4 essential steps. The first step is assessment of the conflict, or in this instance, the occupation or purported occupation. Step 2 is the assessment of the impact or likely impact of business activities on the conflict. Third step is identifying the business impact on human rights. That's through a human rights risk assessment. And step 4, which is of course the most important bit, which is acting to meet the responsibilities which have been clarified during the first 3 steps. That's planning, implementing, and evaluating the business activities accordingly. And so you are talking about a pretty complicated process. A full spectrum heightened due diligence process is calls upon the business to really look at the dynamics of the occupation, which of course can be changing and evolving, and to take further steps to try to understand effectively how those activities, how those products that the businesses produce, how the use of resources by the business impacts the dynamics of the conflict or any human rights violations that are occurring. So, these are extremely complicated inquiries and require, in many instances, deep investigations. And so, simple answer: the sooner you get going, the sooner you get to bottom out some of these complex answers. And, there are some due diligence which can be conducted perhaps without calling in third-party experts, but I doubt very much whether a business can conduct these assessments themselves, relying upon their internal resources. And so the sooner the right experts are hired, the better. And that, of course, should be before any business activities. That's just logical. And most importantly, it should be a periodical process. Once conducted, that is not the end of it, because as I made the point, and as Richard has clarified, the situation evolves. And so what happens today, I mean, Israel and the occupied Palestinian territories is a very good example. You know, what was happening pre-October the 7th, quite different to what is happening after October the 7th, or at least has the potential to be significantly different. So it's as soon as possible and as often as is necessary.
Very interesting. I'll turn to you, Richard, quickly for your reflections, and then we've got a question in the chat.
Yeah, I don't have much to add. I think there's certainly nothing wrong with doing this type of assessment up front, but in the cases that we worked on, the businesses had already been in the planning stage for years beforehand, but had not started operating. So they certainly hadn't committed any human rights violations. But they had undertaken, these are massive projects, and they had undertaken commercial assessments, they had done environmental impact assessments, they had spent a lot of time meeting the various partners and planning the operation. And I guess it was at that stage where they felt that they were ready to go ahead that they brought in the outside experts to say, okay, give us a plan for this, for the complexities of the human rights issues that we face. And that's a perfectly reasonable way to do it, I think. So as long as you get that assessment before you start to build, then that's absolutely fine. And there can be quite a lead time before that happens for the big projects.
Great, thank you very much. And Wayne, I'll turn to you first with this question, due to its focus on Israel. For a corporate sustainability professional working in a multinational company with operations in Israel, subsidiary sales, etc., what are some ways to raise awareness, to question or challenge business activities in an illegal occupier? What would be some tips for middle management in a company that is profit-driven? Thank you.
Raise awareness to whom?
Yeah, so I think what this question is driving at is how do you get that internal buy-in in a business that is profit-driven, that is operating in this sort of situation in Israel? What are some ways to raise awareness internally, or question or challenge the business activities that are at the core of a business, particularly with middle management, those that are trying to drive change perhaps in the business? I think we've seen a number of examples in our own work where this has been the challenge in terms of getting the internal buy-in to conduct this sort of assessment prior to perhaps some more kind of formal pressure coming from externals. Yeah.
Yeah, well, it's certainly, as you say, Lara, a feature of our work, which is, you know, middle management or sustainability teams showing huge enthusiasm for heightened due diligence and for ensuring that the business activities are responsible. And then after the initial enthusiasm, a roadblock occurs, which is that the executive board or the top management suddenly get shy about those activities. There's no simple solution, of course. And every company is different. Every company has a different culture. Every company has different relationships between the middle management and above. But, you know, from a advisory perspective, you know, what we try to do is make the law less scary, make it more understandable. You know, many occupations may well involve violations, but many occupations may not amount to annexations. And so there is room to maneuver in terms of business activities, in terms of labor relationships with the occupied people, in terms of what we've been discussing, the best interests of the population. And so, you know, there can be no blanket assumption that working in an occupation involves human rights violations. However, of course, the more the violations stack up, the more it begins to look like an annexation, the more it looks like systemic or systematic violations, the more that becomes it becomes more difficult for businesses to operate. So I think the starting point, certainly from companies like ours beyond, is to try to explain these things as simply as possible and not over complicate issues by dressing things up in legal language. I hope I didn't do that. What I was trying to do was really sort of try to explain to businesses that there is a way through this. It requires work, it requires explanation, it requires clarification, but there is a way through this, and the way to do business in many occupations in a responsible way. And so I think, to me, I mean, that's as good as I can explain, which is how we try to persuade executive boards and top management that their best interests lie in doing this analysis and making sure that they put themselves in the best position to maneuver through what may be worrying violations, but are not made less worrying because they're ignored.
Yeah, and to whoever, it was an anonymous question, but to whoever wrote that question, if you would like any case studies of why proactive rather than reactive assessments are better, we can provide them to you. So if you ever need the kind of reasoning that you can sell internally, we do have some good examples of that. I wonder whether maybe, Richard, I can pose this other question to you in the interest of time, just so that we can try and answer as many as possible, unless you have any other comments on that question, which feel free to add. But how important do you think robust internal whistleblowing arrangements are for a business to monitor compliance with and identify breaches of HRL and other laws during operations in occupied territories?
Well, I mean, first of all, you would hope that it wouldn't be necessary to have whistleblowers exposing the abuses of a business if the business had had a proper human rights assessment and proper advice and had followed that advice, and they have their policies in place, they have their monitoring in place, etc., etc. But I think that whistleblowers do have a place in certain contexts, in certain businesses, because it can be very difficult for people from the outside to understand what's going on the inside. If you're in a very complex environment, let's choose another one, Eastern Congo at the moment, where there are business operations going on from Western companies, it's very difficult to know what they're actually doing because it's very dangerous and high risk area to go. So there's very little monitoring. So I think whistleblowers do have a place in certain contexts, but and can be very valuable. Yeah. But again, you would hope that responsible companies would not be worried about that because they would have be abiding by the human rights rules.
Thank you. In terms of the next question, just to something that's been posed in the chat, and I'll put this one to you, Wayne. Considering a similar approach to the one that Richard has taken in Western Sahara, how do you think the businesses should operate on the Palestinian territory? This person says, I'm used to interpreting the law as imposing to cease every kind of operation in the OTP, as businesses usually disrespect the Palestinian population, exploiting their labor and resources at cheap prices while fueling the Israeli economy and thus its crimes. But do you think some activities would benefit the Palestinian population?
It's a very good question, actually, and one that I think, you know, only the Palestinian people can answer in a sense. What I would say is this: the international rulings on the Israeli occupation of Palestinian land are very clear. There's not the kind of nuance that there may be in Western Sahara, which Richard addressed. The law is fairly clear and corroborated by a variety of sources, and not just the International Court of Justice, which I referred to, special rapporteurs, UN, academics, and so on. So the law really clarifies that Israel has annexed through settlements in the OPT, and that annexation rests upon a variety of violations of international humanitarian law, such as the forcible transfer of population, transfer of the Israeli population into the occupied territories, the taking of resources which belong to the Palestinian people, violation of the right to self-determination, violation of the discrimination, and so on and so forth. So let me put it this way: the room for businesses to maneuver in the occupied territories in light of these findings is very, very narrow. I wouldn't sit here and say that it's impossible to operate in the occupied territories, in particular the settlements, without violating one or more of these international rules. But it's very difficult. And I think the question does come down to why I think it's a great question, is it comes down to essentially consent of the Palestinian people, which is why I can't answer that. So you'd have to focus in on the business activity, focus in on where it is happening, focus in on specifically what it does, and focus in on whether the Palestinian population in that locality consent to and benefit from those business activities. It's a sliding spectrum, of course, and as I say, without a doubt, the room for maneuver for businesses is extremely narrow.
Brilliant, thank you. And with my eye on the clock, I just want to give Richard the opportunity to answer this question. Are there legal mechanisms available to seize the assets or profits of businesses operating in occupied territories where such profits result from unjust enrichment?
Yeah, there's all sorts of potential legal action that can be taken. There's criminal action using anti-money laundering laws and others. There's human rights sanctions regimes. There are all sorts of both criminal and civil actions and quasi-legal actions like sanctions. But of course, those you have to persuade a significant country or region like the EU or the UK or the US to impose those sanctions. For the criminal and civil actions, you have to persuade prosecutors to go forward. For the civil actions, you have to persuade judges to find in your favor. There are potential actions, of course.
Wonderful, thank you. Well, I think that's where we'll end the session for today. Thank you to both of our speakers for such a rich discussion, and to everybody who joined our third session in our series on business operations in conflict-affected and high-risk areas. We've covered a lot of ground, and we will circulate a few key takeaways and the recording after this session. I hope it has been helpful in giving you some practical insights and tools to help your businesses or organizations navigate these issues. And thank you again for being with us today. Thank you.